Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, first case we'll hear this morning is Mission and Integrated Technologies versus Clement, and it's Mr. Mills. We'll hear from you first.
May it please the court, Lauren Mills on behalf of Mission Integrated Technologies, which I will call MIT. This case concerns a business conspiracy between a father and son to, in the words of the son, shaft the majority owner of MIT into giving him a 10% stake in the company.
Why don't you pull the microphone right in front of you?
Thank you.
Yeah, so we can hear you. Yeah.
I brought a visual aid because the fundamental issue on appeal in this
Bring
case.
some binoculars for it?
Excuse me?
Bring some binoculars to see that?
I'll do my best to illustrate it.
You know,
I tried to
we allowed you to do that. We didn't add the notion that they almost are never useful because we can't read it from here, number one. You have provided it to us on paper, and we can see that. But we've allowed you to have it there, and it's a nice decoration, but I can tell you, we can't read it.
Thank you, Brian. What I'd like to focus on, the fundamental issue on appeal in this case is statute of limitations. And the court erred for one reason. It didn't even say what choice of law it was using for the statute of limitations on the contract issue. And for that reason alone, it's reversible. But here's the timeline that will help you appreciate the statute of limitation on the other issues. Nothing for statute of limitations purposes before 2017 matters. That's because between 2013 and 2017, all the information relates to the development of the Ares 1, which was a commercial failure. In 2017, the Ares 2 was redeveloped. A company called Cardinal Scientific was hired.
Now, which one of the issues are you talking about? Because as I looked at it, it looks like each one of these claims, the analysis of whether the statute of limitation applies depends on the particular facts of that claim, as well as the applicable statute of limitations.
That's exactly right.
But you are speaking more generally, saying the statute of limitation, nothing mattered before the end here, and I'm not sure that applies to all of them, or does it?
I think it does, Your Honor, and let me explain why, and I'll go through as I hit each relevant day why that's important. Cardinal Scientific is hired in 2017. It develops a prototype at great expense. That prototype is demonstrated in Waldorf, Maryland, to a delegation from the United Arab Emirates. A week later, Timothy Clementi, who is the president of MIT and the father of Josh Clementi, secretly files a provisional patent application in his name and in his son's name. He does not tell the majority owner of MIT anything about this or anybody else.
What claim are you talking about? I'm right with Judge Wynn. I think it's much better if you're talking about the fiduciary duty claim, which they have different limitation periods. For instance, the conspiracy to file the patent claim, the patent has been invalidated, so all the patent claims seem to be somewhat moot, it seems to me, but you do have a fiduciary duty claim, you have a fraud claim, and I think it'd be much more helpful to us if you could start with a claim you're talking about and address the limitations with respect to any given claim that you think is appropriate.
I'll start with the business conspiracy claim, Your Honor, because I think that's the easiest.
Well, the business conspiracy, the object was to file the patents, right?
The object was to usurp the intellectual property rights.
I understand, filing the patents. The object, it was the patent, filing the patent secretly.
Correct, Your Honor.
Okay, but the patent has been invalidated, so
It was invalidated at great expense to MIT when they asserted against it, and he had to spend hundreds of thousands of dollars to invalidate 16 out of 17 claims of the patent. He incurred significant damages, and it interfered with the business for years until the patent was invalidated. It's serious damages.
Why was it invalidated?
It was because it was on sale to the UAE in 2017, and so it violated the on sale and prior publication bar under the Patent Act. That's why it was invalidated.
Well, you got to have an underlying tort. What's the underlying tort?
The underlying tort, there's fraudulent concealment and there's intentional interference with contractual duties.
Is that what you put in your complaint?
Yes.
Well, I thought the complaint alleged the underlying tort was a misappropriation of trade secrets.
No. We were very clear in the counts, there's multiple acts within the business conspiracy timeframe. And the issue under Virginia law.
You did, as I recall, when this was addressed below, and you were asked, you referred to your count 5 as the underlying tort in the proceedings before the district court.
I believe that's fraud.
Yeah, that's the fraud count.
Yeah.
And if you look at the fraud count, it talks about, it looks to me, to correct me if I'm wrong, activities going back even to 2013 when, is it Josh? Josh
Correct.
Received confidential information under, I think the claim is the belief that he had signed a non-disclosure agreement.
Okay.
My point there is that goes back a long ways. As you described the underlying tort to the district court, not you, your party, maybe you. It's not.
It was.
I'm not even criticizing. I'm just saying I think that's what you said.
Right. And each independent act restarts the clock under the business conspiracy statute. And the key independent act here is November 2018, when Josh Clementi files a patent in his own name with the help of his father, who has fiduciary duties. He's the president of MIT, he's a member of MIT, and Josh induces him to breach those fiduciary duties to assist him in filing the patent. And that's an independent wrongful act. And the way the case law teaches it's wrongful or tortious, wrongful act right there on behalf of both of them, and that's within the 5 years.
What was the wrongful act? Breach of fiduciary duty?
Excuse me,
Was the wrongful act the breach of the fiduciary duty?
It's multiple. It's a breach of fiduciary duty, and it's the interference with the contractual relationship by Josh.
Well, the contractual relationship, which one are you talking about?
Well-
Josh didn't sign anything.
Well, that's disputed.
If you want to address that, we can go into that. There's a
Yeah.
little email that says the disclosure agreement was sent to Josh to be signed, and that's the total evidence.
No, it's not, Your Honor. No, there's an agreement in 2022 signed by Timothy Clementi where he says that Josh signed the agreement, and then in 2024, summary judgment, he.
Oh, how's that create an agreement? A non-party to agreement says somebody else signed an agreement? He didn't say he saw it. As a matter of fact, he denied he saw it.
That's not.
And the son, Josh, said he didn't sign it.
The first time Josh Clementi said he didn't sign it was 2022.
Where is your evidence that a contract was actually signed?
Okay.
I mean, the fact that Tim says so?
Yes, Your Honor. Tim
Well,
said he sent
He
it
didn't
to
say he
his.
had personal knowledge of that. He said he sent it to him to sign.
His testimony was that he couldn't locate the contract, but that he always believed his son
He
had signed
believed
it.
because he sent it to him to be signed.
Yeah, and
he
his-
assumed that happened, but that's not
His roommate, Wes Regenball, at the time had signed the agreement, and it was never denied. The first time it was denied was in 2022, and Tim signed a sworn affidavit that Josh was under an NDA, and it wasn't until 2024 that Tim changed his tune in a summary judgment affidavit that there was no contract. So it's clearly a
And
disputed
that would
fact.
change the whole business of everything we know about contract law. If a company can simply says that one of our officers believes that someone signed an agreement, I don't know of a case we've ever held that says that's enough to say we're gonna enforce a contract, or do you?
I think he's saying,
How about give me a case on that?
in the insurance coverage, there's millions
Give
of,
me one case.
I don't have one off the top of my head, but
Come back, come with that one case tells me all they had was an officer who said, I believe he signed it.
in the
And
insurance.
that's enough to say that's a contract. Don't even know what it is, because where is it? I mean, I don't see it in documents, so you don't have that. So you're going on basically, I guess it's some form of hearsay or some kind of
Well,
outside evidence.
it's like the missing policies cases and insurance coverage cases, where the environmental towards the policies goes back
Totally
decades.
different.
They're both contracts.
Totally
And
different.
the
The
issue,
policy is more of a standard type thing, that's what insurance companies do and stuff like that. There's some evidence they had something from the inception. You don't have no evidence there was ever anything received by this company, asked for multiple times for up to 5 years, never got anything. And the best you have is he believed it was, someone believes, one of the defendants believes it was signed.
well, and he was told by the president of the company for years that it was signed and just could not be located. And that's our evidence. I'm not arguing with you. That's what we have on this. Now, for the business conspiracy, this date is an independent wrongful act. It's clearly within the 5 years. Okay.
Well, I can't read that. What conduct?
November 20th, 2018.
No, but what conduct?
It's the filing of the provisional patent application in Josh Clemente's name only. Okay, it's an independent wrongful act. Okay, now, the issue is that the statute doesn't even start to run until the injury is felt.
So I'm still having a little trouble with the focus on that conduct. So help me with this if you could. If conspiracy requires an underlying tort, and you've indicated to the district court that underlying tort is your count 5 fraud claim, and your count 5 fraud claim talks about the disclosure of information to Josh when he didn't sign, under the assumption that he had signed an NDA when he hadn't. And that's how I read the complaint and your representations to the district court, and now it seems like we're moving to a different conduct.
I don't think so, Your Honor. If you
Okay.
read our count 3, it's never changed.
I'm talking about that you, fair enough.
Yeah.
Maybe my memory of the proceedings below are wrong,
Yeah.
and that could be the case. But I thought you pointed to count 5 as your underlying tort.
No, count three, we've always focused on November 18 in count 3. That
You're
this is
saying
the-
you didn't tell the district court that the underlying tort for count 3 is your fraud claim?
No, and I wouldn't have said that because that's not the law. The law is wrongful act or underlying tort. It's 2.
Well, filing a patent's not a wrongful act.
It is if you're encouraging your father, who has fiduciary duties, to go along with you in the conspiracy to shake down the owner of the company for 10%.
But that's not the filing of the patent.
That is-
That was just, the filing of the patent was just an act. I mean, it's a legal act.
It is.
And he had authority to file it on behalf of vis-à-vis the patent office, didn't he?
He can file it, but he can't coerce his father into helping him and then keeping
I
his
mean, he was an
father-
officer of the company. He was a partner, whatever.
Timothy was, Josh was
Yeah.
not. Okay, Josh is inducing his father to breach his fiduciary duties.
I thought you said it was the filing of the patent by the two of them.
Well, no, it's filed in Josh's name only. It's filed in Josh's name only. There's an earlier patent filed in both names that is abandoned, becomes irrelevant. The only thing that's relevant is that Timothy Clemente takes the information from that patent in November of 2018 and gives it to his son to assist him in filing it, and then fraudulently conceals it from Mr. Alubad until 2022. And so there's no injury until this patent publishes. Now, in 2019,
But if the patent is invalid, there's no injury at all anyway.
other than the $500,000 he spent to invalidate the patent.
Well, that's not the filing of the patent.
Well,
In
that's
other words, the tort,
the tort is the fraudulent concealment of this, because here's the next thing, 2019. There's bad blood after this because the Aries is a hit, Josh wants 10% of the company, and he doesn't get it, so he storms off and secretly files this. In 2019, they're having a meeting with lawyers, and Mr. Alubad asks Mr. Clemente, do we have a patent? And he says, I do not.
Didn't he say that, I mean, I can't, again, it's important to say exactly, because there's a recording of that or transcript of that, and he says, have you filed a patent?
He does, and he says he has not. He personally has not, is
Right,
what he says.
but he was asked if you personally had filed. Now, you can say maybe you should have said more, but he didn't say, do we have a patent? He
Yeah.
said, have you filed a patent?
Right, and he very cagily answered, I have not filed a patent. But at that point, especially given the context, he's the president of the company, and he doesn't say that, but by the way, I've secretly helped my son to
Fair.
file a patent.
And that may be, I mean, that in some of your pleadings there certainly can be a duty to speak by a fiduciary, and you can argue that, but you still have to overcome inquiry notice even with that, correct?
I think that's right. And the first time there's any inquiry notice is the publication of the patent. Okay, much later in 2021.
Why not, why wasn't there not inquiry notice when, in that same meeting you're talking about, Tim says, Josh really is the inventor of all this. It's all in his brain. Isn't that an indication that he thinks he's got ownership of that intellectual property?
And yeah, I think that's right. And he's making the inquiry at that time about the patent, and Tim cagily answers it. He can't hedge like that. He just can't. He has the duty at that time, it comes up, there's a patent pending. He has a duty even before that to tell him, but when the question is put to him, he's the president and fiduciary of the company, he has to tell him at that time. And then he lulls him. And so there's no reason for Mr. Alabad to look anymore. There's no reason for a guy who's not a patent attorney to scour the patent office. So the next time, the first time there's any potential injury here is when the patent publishes. And it's not really until November of 2022 when the patent finally issues that there's any real damage here. Because now there's a patent. Now, I want to talk about the contract claim really quickly because it's been mischaracterized. We have a breach of contract claim. It's count 1. It's based on a breach of Section 7D of the MIT operating agreement. That is a contractual claim. We styled it a fiduciary duty claim because they are contractual fiduciary duties. It's the way the LLC Act works in Delaware. And so we're into the Delaware statute of limitations, which is 3 years subject to equitable tolling. And there's no better reason to equitable toll than Tim Clementi fraudulently concealing his participation in this and then being very cagey about how he answers it. And so so Mr. Alabad was not on notice of this until the patent issued. It's well within the 3 years of the statute of limitations here. And so those are the two big counts. We've belabored the breach of contract claim with Josh Clementi. He's unjustly enriched. He still has a patent with one claim. And it actually inhibits MIT's business. He can't put a ramp on the Aries because the prototype did not have a ramp, and so that last claim was not asserted. So he still has a patent. It's not moot at this point that he could assert against him. And so with that, I see my time is almost up. And
You have some rebuttal.
Yeah, thank you, Your Honor.
Okay. All right, Mr. Henson.
Malfunctioning or something.
Yeah, I know,
I guess they can see it.
barely.
Presumably he can see it.
May it please the court. My name is Andrew Henson. I'm here on behalf of the appellee, Tim Clemente. I'm joined here by my colleague, Rebecca LeGrand, who's here on behalf of the appellee, Josh Clemente, from whom you will be hearing later. At the heart of this case is that MIT's majority owner, Fahmy Alabad, induced Josh Clemente to use his skills as an engineer to redesign the Aries, which is MIT's only product, based on an oral promise that in return, Josh would receive an equity stake in MIT. Now, in late 2017, when the Aries redesign proved highly successful, Mr. Alabad broke his promise and took Josh's work without compensation.
So you're going to walk us through these claims? I mean, there were 7 claims, 2 of them dismissed, seems like there are 5 or so, and the main issue, at least for most of them, is the question of the statute of limitations. There's some question as to underlying to it. That would be helpful, I think, to us if you will address them in that order so that we can understand.
I would be very happy to do that, Your Honor. I would be very happy to do that. And allow me to take the business conspiracy claim first. And as I do that, I'd like to correct the record. Judge Quattlebaum had a question regarding the underlying tort for the business conspiracy claim, and the underlying tort matters for the purpose of determining when the statute.
You might do better to answer Judge Wynn's question.
Yes, Your Honor. And so the statute, all I'm trying to say, Your Honor, is that the statute of limitation begins to run for a business conspiracy claim when the underlying tort experiences just enough injury sufficient for a plaintiff to bring a claim, a cause of action. And so, but here, in the pleadings.
3 years?
Sorry, Your Honor?
The period is 3 years?
For a business conspiracy claim, the period is 5 years.
5 years, okay.
Yes, Your Honor. And there's no tolling in Virginia law for this business conspiracy claim. But the underlying tort at issue here in the pleadings was a claim of misappropriation of confidential information and trade secrets. However, MIT has dismissed its trade secrets claim. It admitted it cannot prove it for the same reason that it can't prove the existence of any confidential information. In the proceedings below, this is at page 1158 of the joint appendix, MIT instead argued that it's the fraud claim that count 5, which is the underlying tort. And as the court will be able to see, the tort claim at issue here all relates to conduct that occurred in 2017 or earlier. This is at pages 41 and 42 of the joint appendix. You can see all these allegations are for significantly older conduct. And so whether it's fraud or whether it's misappropriation of confidential information, the harm at issue here occurred at the very latest at 2017 when MIT alleges that Josh received confidential information from Tim without the protection of an NDA or under the fraudulent guise that there was an NDA. Now, I'd like to note that we completely reject this characterization. In fact, this is Josh's work product. He was never compensated. He was never an employee of MIT. He was never a member of the LLC, and there's no contract.
What about your colleague's response that, well, there was additional conduct in, I guess, 2018 that is independent and re-triggers the statute? Do you have a response to that?
I do, Your Honor. So the issue, so MIT is now claiming that the conduct occurs at intervals. And I think it's important to note that the Virginia Supreme Court, the Supreme Court of Virginia, has never recognized that misappropriation of confidential information is the kind of harm that it can incur at intervals. In fact, the very nature of a disclosure of confidential information is not susceptible to that sort of characterization. So this is...
Wouldn't the point be if in 17 Josh has the confidential information without an NDA, that any additional publication, isn't, maybe more harm, but the harm's already occurred, and once you've lost your trade secret status, it's not like, you might argue filing the patent doesn't make any difference there.
Exactly right, Your Honor. The genie's out of the bottle. You can't put it back in. Once something is disclosed without a protection, it's lost forever. You can't recreate a trade secret or recreate the confidentiality of something that is now in the public domain. And that is why, by its very nature, the allegation that is underlying the business conspiracy claims is simply not susceptible to a notion of the statute of limitations occurring at intervals or a harm occurring at intervals.
We're not trying to tell you what to do, but several times we've suggested going through each one. You might want to move on to another one and kind of
yes, Your Honor.
Statute issues.
Yes, Your Honor. So that's the business conspiracy claim, and I'll turn now to the breach of fiduciary duty claim. So a breach of fiduciary duty under Delaware law.
Is this count 1?
This is count 1, Your Honor. Okay. Yes.
So you're calling it breach of fiduciary duty. He called it breach of contract.
Yes, Your Honor, and I'd like to just address that briefly, which is, by its terms, it is identified as a breach of fiduciary duty claim. It's not a contract claim. And in fact, MIT asserted 2 other claims for breach of contract in the very same pleadings at counts 6 and 7, in both cases giving them the label of breach of contract. And moreover, MIT distinguished in a claim for injunctive relief against Tim, but to seek to enjoin Tim for violating his contractual and fiduciary duties, which would seem like an unnecessary distinction if MIT only had ever sued Tim for breach of contract.
What difference does that make?
It has a substantial difference, both in the limitations period and in the preemption under the Delaware Uniform Trade Secrets Act.
The preemption, I get that.
So the Delaware courts have interpreted their own Uniform Trade Secrets Act as preempting all other tort theories based upon a theory of misappropriation of confidential information, regardless of whether the confidential information rises to the level of a trade secret. So the whole thing is preempted.
Can't you argue that even if it's contract, because it is referencing the operating agreement in some way, wouldn't you also argue that even under that approach, that it fails under the breach of contract statute of limitation?
Absolutely right.
So the tort contract Your success isn't dependent on us going with you on tort versus contract.
Absolutely not. And so I think it is so there's a 3-year statute of limitations if it is a contract claim, which we contend is not. But the MIT appears to acknowledge that its claim is untimely under the default statute of limitations because it's seeking to rely upon a tolling doctrine.
So maybe I'm oversimplifying this, but you're dealing with a breach of fiduciary duty. Cutoff date, I think is agreed, is October 16, 2020, 3 years from the time it was filed. The question is was it equitably tolled beyond that period of time such? It seems to me perhaps the strongest, or at least strong evidence of it might be that August 2019 meeting. Was that inquiry notice at that time?
I'd like to address that directly, Your Honor. So in this meeting, so this is, I think we should note a few things.
Is there something stronger than that you have, than that meeting? It seems like that meeting is very critical on this, because that's the time in which style, depending on how you look at it, could have been he was cagey in terms of trying to cover it up, but nonetheless, he revealed that Tim could have this agreement, or no, could have this patent. Seems like to me that's very strong.
So yes. So let me. I think we should first note that it's MIT's burden to prove that a tolling doctrine applies, and it only applies in rare and unusual circumstances. And this is one comment and one conversation. That's the whole basis for their tolling argument. And I would also note that they've never argued equitable tolling in the courts below. We submit that it's not preserved for appeal. The only argument they've asserted is one of fraudulent concealment. But turning directly to Your Honor's question, the question by Mr. Alabad's attorney to Tim Clemente was, do you have any patents on this? Have you ever applied for any patents? And there's no dispute that Tim answered honestly. He said, I applied for a patent a few years ago, but I don't currently have any patents. So MIT is trying to fault Tim for not answering a question that he wasn't asked. And they have produced no case showing that such...
Didn't he go on to say something more in terms of Tim's?
Absolutely, Your Honor.
He then focus. We can get the part about, okay, maybe he answered it honestly or whatever, but it seems to me is what he said after that. That's pretty strong.
I completely agree, Your Honor. In the same conversation, he tells Mr. Alabad, with his counsel there, repeatedly that you don't own what Josh created. And he urged him to compensate Josh so that MIT could acquire the rights to the product that it was selling.
Go ahead and finish that, I'm sorry.
Well, I mean, in this conversation, Mr. Alabad had no reasonable basis for thinking that Tim, in the exercise of his duty as MIT's president, would be protecting an asset that he didn't believe that MIT owned. And he had no reasonable basis for believing that MIT did own it. Tim was never...
Can I follow?
Yes, sir.
Do the multiple times that Mr. Alabad asked about the non-disclosure and was told allegedly that, yeah, I think he signed it, but he can't find it? I mean, does that go into inquiry notice as well? It seems to me, if you know someone has access to confidential information, and you're being told that, yeah, he signed and can't find an agreement, and you don't ask to sign another one, does that go into inquiry notice?
I absolutely believe it does, Your Honor. I think it goes into inquiry notice for the purpose of restarting the limitations period, even if a tolling doctrine did apply, which is unlikely. But moreover, I think it's the same for the common law fraud claim, which is count 5. That has a 2-year statute of limitations that runs from the period in which, with the exercise of reasonable diligence, the plaintiff should have known about the fraud. And so here, I mean, there's really an equivalence here between inquiry notice and reasonable diligence. And so, yes, as I noted previously, the fraud claim is replete with references exclusively to being about inducing MIT to allow Josh to work without the presence of a non-disclosure agreement. And the record reflects repeated requests by Mr. Alabad to Tim for where is this non-disclosure agreement? Where is this non-disclosure agreement? And Mr. Alabad explained that as of the sort of dispute that happened in late 2017, he began to immediately ask for the NDA. And now he asserts that there never was an NDA. So yes, that is absolutely relevant to the question of inquiry notice, and it's relevant to the question of reasonable diligence. And I would also add that the NDA in question was for an entirely different entity, Atlantis Consultants. That's the NDA that has been at issue in this whole case. And there's no dispute that the NDA would not have protected MIT even if it had been signed. So this, I mean, it is.
Tim seemed to think so.
Tim was mistaken, but yes, I mean, he was. Mr. Alabad asked him before the creation of MIT in August of 2013. Mr. Alabad asked him, get Josh to sign this NDA, and so he when he was repeatedly asked after the fact if that had occurred, that's what he was referencing. He was referencing the Atlantis Consultants NDA.
He acted as if what is it called? Who's the company?
Atlantis Consultants.
The Atlantis NDA would have applied to the other. Maybe legally that's incorrect, but he acted as if that would have satisfied his obligations.
I think, yeah, he communicated that he thought that the NDA had been signed, but he was mistaken. But so, turning to the to the issue of constructive notice, which is another basis in which the limitations period would run, even if a tolling doctrine applies. Constructive notice can give rise to inquiry notice that would restart the limitations period for breach of fiduciary duty as well. And here they were putting patent pending on the product. And so when you look at the facts of Tim Clemente telling Mr. Alabad in the presence of his attorney that MIT didn't own Josh's work and that Josh needed to be compensated in order to for MIT to own the product. And then Mr. Alabad knowing that an NDA was missing despite his repeated requests for it, and Mr. Alabad himself putting patent pending on the product marketing brochures even long after Tim Clemente's July 2017 provisional patent had expired. This is something I'd like to address in MIT's brief, where they reference that they claim that all of the patent pending references occurred in 2017. That's just not true. You can see in the record there is a reference to in November of 2018, November 2nd, 2018, Mr. Alabad emailed Tim Clemente with a revised marketing brochure where that same patent pending is listed on the product. This is at pages 656 through 666 of the joint appendix.
So maybe I'm not understanding. Why does patent pending on the brochures go to inquiry notice?
Well, I think sort of in the panoply of facts here, where it certainly shows that the notion of patent, of whether the existence of a patent was contemplated. And they had reason to think about, particularly where Mr. Alabad is receiving information that the MIT doesn't own Josh's work and that he can't get an NDA, and the notion of patent was certainly in the mix when it's referenced on these brochures. I think that certainly goes collectively to the notion of constructive notice.
All right. I think your time's up.
Thank you, Your Honor.
Yeah. All right. I guess we'll hear from Ms. Legrand.
Thank you. May it please the court, my name is Rebecca Legrand, and I'm here on behalf of the appellee Joshua Clemente. I'd like to start with an observation and then just make two quick points. My observation is that the district court granted summary judgment quickly and efficiently.
You want to stay close to your speaker here? Thank you.
The district court granted summary judgment quickly and efficiently on essentially all of the appellee's claims because these are straightforward issues. And I'll make 2 points here. I'll start where the district court started, with the statute of limitations. It is not a difficult conclusion here to find that all of the claims at issue are untimely. As has already been referenced, the complaints...
But only certain of these counts apply to your client.
Correct, and I can speak on...
Which counts are those? Count
So the first count that applies to my client is the business conspiracy count. Then there's an unjust enrichment count, which is count 4. And then the breach of contract count, which is still here and is count 6. So those are the 3 counts that are alive and exist again, or, well.
Which of those are you addressing first?
So I was, in part because I have only 3 minutes and 48 seconds, I was making a broad point that I think for all of those claims, it isn't hard to see that they're stale. It isn't hard to see that key events happened more than 5 years ago, which means the statute of limitations for either, for any plausible claim has expired. Because 2017 is before, the statute of any claim brought after October 2018 is stale under a 5-year statute of limitations. And the focus by the appellant here today on what they believe was unfair things that were done in 2017, claims accrued no later than then. And under any plausibly applicable statute of limitations, be it 5 years or 3 years, those claims are stale. And I think that's why the district court reached that conclusion quickly. And then pivot to a second point, which is sort of related. The trickiest thing in responding to appellant's statute of limitations argument has been, they frequently say, well, we couldn't bring a claim yet because we weren't damaged. Because they can't get around the fact that they knew that they were fighting, essentially, starting already in 2017, more than 5 years before they brought a claim. So their only explanation for why these claims aren't stale is, well, we weren't damaged yet. But as my colleague already pointed at, the law does not permit that. Any injury, no matter how minor, starts the clock ticking for the statute of limitations. And in claims that involve alleged use or possession of confidential information that allegedly someone shouldn't have, the harm happens when that person gets the information, not when they monetize it, not when they patent it, when they get it. And the allegations that...
When did Josh start working on Ares 2?
2017, Your Honor. Early 2017.
So in early 2017, Josh is developing know-how and technology in connection with the device, and everybody knows he's doing it. And he's not an employee, he's an independent worker, and the relationship has not been solidified with him between MIT and him, and he's got this information. So the argument that MIT seems to be making is that it somehow is entitled to that information because it hired him, even though they don't pay him. Or I don't know what the claim is, but in the big picture, we're talking about technology and the loss of technology or who owns the technology, and it's just very poorly documented and followed through. The best would be that if he, in 2017, signed an NDA, then MIT might have some claims. But the question is, if he's working as an independent contractor for MIT, although even that is not well established, it's a funny relationship. But the fight is over technology being developed in 2017 about which everybody had knowledge, right?
Correct, Your Honor. And so because Josh was not an employee, because Josh had never signed an agreement with MIT, the only argument that MIT could plausibly have to ownership of this patent would be based on there being an additional inventor. But that would be a claim about inventorship that would need to be brought under the Patent Act. Federal preemption is strong in the area of patent law, and rightly so.
What do you understand to be MIT's claim to any of this technology?
I will do my best.
The basis for it. The basis for the claim that they somehow own the technology.
Honestly, Your Honor, it has shifted, but let me do my best on their behalf. I think the best argument the argument they've made most recently, I think, is if Tim had been named as an inventor too, because Tim was a member, then there would have been some ownership rights. But Tim was not the inventor. Joshua Clemente was the inventor. And if a dispute about inventorship must be brought through the Federal Patent Act, not through common law conspiracy claims or unjust enrichment claims, because it turns specifically on inventorship, which is at the heart of the Patent Act and preempted as a result. There's no argument that there was a contractual right for MIT to have an ownership stake in Joshua Clemente's invention. It is true that Joshua Clemente had hoped that that was what was going to happen. He did indeed. They'd had numerous discussions. In fact, Josh Clemente had been promised that he would get an ownership stake in the company eventually, and that's what he wanted. And he's working with his father, who was the president of the company. So yeah, people were working on trust a little bit here because it's family. Unfortunately, the majority owner.
Well, it sounds to me they're working on anticipation of some relationship that never consummated.
Correct. And MIT took the risk that there would be no agreement, and there wasn't. There were certainly plenty of opportunities for them to reach an agreement, including, and this is in the record, and the judge noted it, because it's in discovery, it's in documents
All right.
that
Thank
were.
you. I think your time is up. Right.
Thank you.
All right, Mr. Mills. Maybe I'll ask you that question too. Is here in 2017, Josh is working on this device, and clearly Tim is telling MIT that he's the inventor of this device. What is the claim of any ownership in what Josh did? What's the basis for MIT's claiming any ownership in what Josh did?
Here's what happened in 2017. Mr. Alabad spent $1 million hiring Cardinal Scientific to develop a working prototype of the Ares and demonstrate it at its facility in Waldorf, Maryland.
Well,
he hired.
But that doesn't give him the right to the thing. The question is, he was relying on the fact that Josh somehow would be in a relationship with MIT. I mean, if Josh was the inventor, the fact that somebody else later built it doesn't mean that that person who built it becomes the inventor.
I think that's correct, but this is for, and you accurately say this is poorly documented and messy, and I agree with that.
But this is a fight about ownership of inventive rights, of technology.
And confidential information. And
Well, the confidential information is only confidential if it is confidential. I mean, it was known by Josh. Josh was not connected with the company.
Well, here's what happened. They paid Cardinal Scientific to develop computer-aided design files, and Josh signed as the VP of engineering of MIT a contract with 21st Century to develop the software, the source code for the wireless controller, and then he kept it. Okay, that was information paid for by MIT, signed for by Josh.
That was in 21, though, right?
No, that's in 2017.
27.
That's in 2017, and he didn't give it back. That was one of the reasons. We abandoned our trade secret claim, but we still have a confidential information claim. But one thing I would like to clear up, committing a wrongful act outside the statute of limitations does not provide defendants with carte blanche to commit new wrongful acts within the statute of limitations. That's not the law of Virginia or Delaware or anywhere else. And that's exactly what happened here. Okay, and so the argument that some kind of a continuous tort is just wrong. These are new independent acts with new injuries. And there was an inquiry. That August 19th meeting is really important.
I don't quite understand that, because the technology was being developed to everybody's knowledge in 2017, and Josh was a big player in that. And Josh was trying to protect his creative interest in it. He had no legal relationship with MIT. He anticipated it and requested it, and the two had these exchanges about the NDA and about getting a share and being paid. The fact that there's later efforts to shore that up or something doesn't change the statute of limitations. It seems to me if you wanted that technology protected, you have knowledge of its unprotection in 2017.
I don't think that's right. He's working under the direction and supervision of his father, whose duty. I see my time is up. May I answer?
Okay.
Yeah. May I answer your question?
Go ahead and just finish.
Yeah, he's working under the direction and supervision of his father, whose duty it is to protect the information. His father had testified that he thought he was under the NDA.
But his father's has a duty to protect. His father doesn't have the information that the information that is being developed at that point is being developed by Josh, and his father knows about it, but so does what's his name, Alaba?
Yeah, it's being developed by Cardinal Scientific, by 21st Century, by Timothy Clementi, in
Okay.
addition.
All right.
Thank you, Your Honor.
Thank you very much. We'll come down and greet counsel and then proceed on to the next case.
Mr. Bonney's 2-year sentence disqualifies him from any opportunity to earn credits over his entire 12-year term. This disregards the plain language of the First Step Act in favor of an entirely separate...
Let me just reduce this. I think this case is an interesting case, and we haven't really ruled in this area. But as I understand it, you have a component sentence. It has two components, one which is eligible and one that's not eligible. And whether it's consecutive or concurrent doesn't matter. And the question is, when one eligible is merged with an ineligible, does that disqualify the whole sentence? And as I understand it, for administrative purposes, if this is an administrative conduct that BOP is doing, we're to treat the whole sentence as a single sentence. There's a separate provision in the statute that says that. And up to now, all the circuit courts, or 5 of them or whatever they are, have concluded that since it's treated as a single administrative sentence, if a component is ineligible, the whole thing's ineligible. I don't know if that result necessarily follows, but it seems to me that's the issue before us, and I think it's a very interesting issue, and I gather you would agree that's what we're coming to, is when you have a multiple sentence which has one component eligible, one component ineligible, is the whole sentence disqualified.
I agree, Your Honor.
That's the issue, right?
Yes,
Yeah,
Your Honor.
okay.
And with respect to those courts, I think there's sort of 2 fundamental issues. First is that they spent insufficient time within the immediate context of the eligibility provision, and that is the First Step Act itself. And second, that they spent too cursory a review on the meaning of the aggregation provision with respect to the unique and mandatory time credit program that was created in the first step.
But counsel, so in your brief, you spend a good bit of time, just like you just said, starting with the first step back provisions, 3632D, and talking about that, how the focus there is on a single eligible or ineligible sentence. And it seems to me there's a pretty good argument that if you look just at 3632, that's what they're talking about. But we got to make some sense of 3584, 3485. I'm sorry if I get the aggregation, statute. And to follow up on Judge Niemeyer and your response, it seems like you agree that needs to be grappled with. And I take it from your brief, the way you say it doesn't apply is your contention that this is not an administrative function. And your argument that it's not administrative seems to be that there's not much discretion. Is that right? Am I characterizing your arguments
That is in
fairly?
large part my argument, that the eligibility determination is not an administrative functioning. To be sure, BOP has to apply the rules that Congress has written for it, so they've got to line up the paperwork and see if the convictions match, but it can't exceed the
Why
means.
does administrative, why does it, you seem to equate discretionary and administrative, and those two things just intuitive to me don't seem to be the same. I mean, I think you could have administrative functions that are discretionary and administrative functions that aren't. I'm having trouble understanding why administrative, why it's not administrative just because it's less discretionary.
Thank you, Your Honor. BOP has not articulated an administrative purpose of the First Step Act that is actually served by aggregation, nor could it. First Step Act time is earned 10 for 30 days or 15 for 30 days. BOP's job is to track the number of days you've earned and tally it up and give you that amount, either an early release to supervised release or early transfer to home confinement. And that's different from other sentencing credit programs like good time credit, which
I agree. I'm not quarreling that it's different. I mean, or at least for purposes of this question, I'm conceding that it may not, those others seem to have a more discretionary judgment or role involved. But why does that matter? That's a difference, but why does that make it non-administrative?
the conflict here is between the way that BOP has interpreted the administrative purposes to interact with the 68 categories of ineligible convictions laid out in the First Step Act. And it is treating 3584 as an override, which allows it to treat a sentence for an eligible conviction as ineligible to earn credits. So for the 10 years Mr. Bonney is serving his drug offense, he gets no credit. Right. And that's why this issue comes up. I think the discretionary...
I agree with that, but maybe I'm not being clear. I understand your argument, and it has a lot of common sense to me, quite frankly. I mean, when I look at this, I'm like, this seems like a weird result, just to be perfectly frank. But, you know, when you read the statute, it seems by your own argument to depend on whether the BOP's role is administrative or not. And I keep going back to the arguments you seem to be making is it's not administrative because it's not discretionary. And I don't know why it has to be discretionary to be administrative. And that's what I'd like for you to answer me if you're able, if you could, please.
Thank you, Your Honor. I think that when you look at the case law interpreting the RDAP statute and the application of the aggregation provision to BOP's interpretation there, it depends heavily on BOP's exercise of discretion to determine who could or could not be eligible to go to early release.
I share Judge Quattlebaum's question. Why we focus in on discretion at all? I'm thinking the Supreme Court's decision in Wilson. And the notion is the sentence is imposed by the judiciary, and the judiciary cannot anticipate credits, jail time credits, either under the Good Credits Act or under this one. It just can't anticipate them, and it commits the defendant to the custody of the Attorney General and the Bureau of Prisons. And at that point, they administer the judgment that was entered. And the statute says for purposes of that administration, the sentence is treated as a single sentence. Then the question comes, which I think is the hard question, is if it's a single sentence and one component is eligible, that made it up, and one's ineligible, does that make the whole thing ineligible? And that has been the practice that has been followed, and the courts have followed. Now, it seems to me it follows in some sense from these statutes and from the concept that the judiciary is finished with the case when it commits the prisoner to the custody of the Attorney General, who's in the executive branch and administers the judgment. I think regardless of whether it's discretionary or not, the sentence is being administered by the executive. But the question still comes then is how is it administered, whether it's and I think it's a tricky question. I don't want to demean your argument because I think it's a pretty good one.
Thank you, Your Honor. Briefly, I think the reason I'm talking about discretion is because I believe that BOP is exercising its discretion to apply the aggregation provision here. And one important point that I don't think has been acknowledged by or brought before prior courts is that BOP doesn't always do that. It doesn't always apply aggregation of sentences, particularly when the sentences were imposed.
It has to treat it under statute. It has no discretion. It has to treat it for administrative purposes as a single sentence. And so the question then is, what does that mean? And it seems to me, if we looked at other contexts, we'd have to examine that question under that too. I don't know which other context you're talking about, and I haven't conducted that analysis, but the argument here is in treating the sentence as a single sentence, it has a component that disqualifies it. And that's the argument. Now, your argument is you can look at the components, and if one component, in this case, is 2 years served, then why doesn't he get credit at least after the 2 years? And I think it's a mighty good question.
Can I follow? I think you were talking about, the BOP doesn't always do that. Are you talking about in the parole and the treaty context? Is that the references in your brief to that?
Those are two of the examples. They also don't aggregate Sentencing Reform Act and Prison Litigation Reform Act sentences because they had slightly different definitions of good time credit. They don't aggregate the VCC LEA amendments, the post-VCC LEA, and I'm saying the acronym because I cannot remember exactly what it stands for, but they don't aggregate there. Their sentencing computation manual is 600 pages long. It goes through every single permutation of every wrinkle in sentencing law and how they need to apply that to administer different sentences.
Is your point in this argument, maybe it's both, but is your point that this shows they have the ability to is it deaggregate or disaggregate, whatever, to unbundle it, I'll just say that that's a doable thing? Or is it your point that those indicate that this is not an administrative function?
Both, Your Honor. I think that it shows that BOP has not always viewed itself as bound by an ironclad aggregation mandate and has interpreted statutory text to trump how it administers sentences that award credits differently. I think it also does show that BOP can track and award credits. And I think that's clear from the record. The Pizarro case is one of the cases where BOP was defending its decision to deaggregate sentences that were SRA.
So it sounds like deaggregate's a word, not just.
Right. I am not confident that is an actual word, but I'm using it.
I didn't know, so. Can I ask you something else that was in your brief that I thought may be one of the stronger arguments is the specific aggregation language in the Second Chance Act?
Yes.
I mean, it presumably 34 or 3584 would apply to that act as well, yet there's some specific aggregation language beyond just what's in 3584C. And I think the point is, well, if you have 3584 does it, why do you need it somewhere else? And the absence of that in the second and First Step Act indicates you don't aggregate here. So I get your argument. I may not have said it as well as you would, but I think I understand it. The warden, I think, responds by saying something to the fact that there's no computations involved with the Second Chance Act. So seemingly that difference matters. Do you have a response to that?
I disagree with that assertion. The provision in question operates by allowing people who meet the criteria to be classified as an eligible elderly offender to go to home confinement or RRC earlier than the second chance generally allows. So the amendments here moved it from 2/3 of your sentence done, you get to go, to 66% of your sentence, you get to go. And if you look in the record, you will even see in Mr. Bonney's sheets, and I'll give you the site when I come back up, there's a computation in there for his eligible elderly offender date. So I disagree with the government.
So you disagree with the premise that there's no computation aspects involved, but I mean, even if there are, that wouldn't be the end of the question, would it? I mean, just because one involves computations and others doesn't, still there's that specific language in one.
Right. I certainly think that it shows, number one, Congress knew how to make clear when multiple sentences would sort of taint the entire term of imprisonment. And number two, that it didn't act against a background principle. That's reflected too in the Second Chance Act, which that provision amended, which defined term of imprisonment to specifically reach multiple sentences. And that was in 2007, which also postdates the 1987 aggregation provision. I think the last point I'd like to emphasize is just why this squares with the purpose of the First Step Act, which was to create a program to incentivize people to earn credits towards early release. It's not a handout, right? In order to get the credits, you have to successfully participate in programming. In order to apply the credits, you've got to prove that you're low risk. That means that you can't misbehave in prison. You can't do other things that are going to disqualify you from that. So it's an incentive. And the reason Congress created that was to reduce prison populations and to save money and reduce recidivism. Congress did this with a healthy skepticism towards the Bureau of Prisons and curtailed its ability to discretionarily administer many aspects of this program, reserving for itself setting the rules of how this would work. And I think their decision to not take a categorical approach in listing out disqualifiers, as they had in prior.
But that sort of cuts against you a little bit, because if 924C is a violation that Congress said we're not going to allow these credits, when a defendant has multiple sentences which involve 924C, that doesn't reflect just on the sentence. That reflects on the nature of the prisoner, which Congress was focusing on. So that if we have a 924C component, it seems to me the better course in carrying out the purpose would be to note that 924C identifies a particular inmate who committed a particular crime that Congress did not want to create this incentive for and have him out on the street earlier. And here we have a defendant that has that component, even though he has another sentence for which he would qualify. In other words, carrying out the purpose includes carrying out the purpose of the exceptions. And so I think it cuts both ways, probably.
May I briefly answer, Your
Yes,
Honor?
of
I see
course,
my time
please.
is up. I would just say that Congress didn't include any criminal history disqualifiers in the First Step
No,
Acts.
but they have that list of, I don't know how many there are, and it's a
Of
long
course,
list.
68.
And in that list, they made a selection, and that selection is based on the conduct involved in those crimes. I mean, they obviously decided that certain types of crimes we do not want back on the street, maybe because recidivism is high or it's whatever their judgment was. So my point is, if a defendant qualifies under, has an ineligible sentence, it doesn't just reflect that little 2-year sentence. It reflects the nature of the inmate, which Congress tried to, those crimes are surrogates for the type of inmates that will not get the benefit. And so if you're looking at purpose, you have to look at that to include that too, I think.
2 quick points,
Yes.
Your Honor. Number one is that Mr. Bonney doesn't get to earn credits when he is serving the sentence for the 924C, which means he has fewer credits to apply.
I understand that.
The second,
But you're again going back to the nature, the particular sentence involved, and my point is a little broader point, which is if you're looking for the purposes of Act creating incentives to reduce recidivism and to reduce the population, Congress clearly did not want to reduce the population and reduce the sentence of certain defendants who committed certain types of crimes. And it seems to me once you've committed that, you disqualify yourself, because every crime on that list is probably often committed coupled with a bunch of other crimes for which the sentence may enhance. And I just don't know how far we could go in describing purpose. I mean, it's a good purpose for those inmates who qualify who don't have one of those sentences. But here we have that peculiar circumstance where he does have an ineligible sentence, but he also at the same time has an eligible sentence. And the question is, does he get the benefit for the ineligible? Do we go back and break it apart? Your argument, I suppose, would be after the 2 years, he should then start qualifying.
yes, it is, Your Honor.
Yeah, I understand that, yeah.
Thank you, Your
Okay, thank you very much. All right, we'll hear from Ms. Hamlin.
May it please the court, my name is Kim Hamlet, and I represent the United States on behalf of the warden of FCI Williamsburg. This case boils down to whether determining eligibility for First Step Act time credits is an administrative purpose of the BOP. It is. The First Step Act requires the BOP to implement a program that allows prisoners to earn time credits.
The time credit statute states is serving a sentence. What's administrative about that?
Yes, Your Honor, the statute says that a prisoner is ineligible to receive time credits under that paragraph. This is section 3632, I'll call it the ineligibility provision, if serving a sentence for a conviction. And there, the BOP is responsible for determining whether an inmate has a sentence that has one of these 68 enumerated offenses. And
Can a prisoner serve a 24 sentence for 144 months? A 24-month sentence, can you serve it for 144 months?
No, Your Honor, and
So at what point won't he be serving that 24 months in 144 months, one for which he is eligible? And I think it's come out in the questioning, but there's something nonsensical going on here. I mean, you got 144 months that's tacked on as a result of 120, which does qualify, and 24 months revocation, not even an offense then, but a revocation of something that comes on to it. And the question says, the 24 months then says, well, you can't get any of it for 144 months because Congress clearly didn't intend to apply that First Step Act for something that would go well beyond 24 months. When it appears to me, we're talking about is serving a sentence.
Yes, Your Honor, and I understand your question, and I think what's important to remember here is that what the BOP is looking at here with the sentence is For an administrative purpose, the sentence is 144 months. That is the term of imprisonment. And this is for administrative purposes, so that's not to say.
What's your definition of administrative purpose? I mean, I share Judge Wynn's just reaction to this intuitively, that just when it doesn't seem to make sense. But we got to grapple with the statute, 3584. So what's your definition of administrative purpose?
So there isn't a definition in the Sentencing Reform Act or in the First Step Act that we can look to from Congress, but we do have guidance from the Supreme Court in United States versus Labonte, 1997 decision out of the court that notes other types of sentencing credits, time served credits, residential drug abuse program, the good time credits, and the court says those fall within Section 3584C's administrative purposes carve out. So there, the Supreme Court.
Wilson said the same thing, didn't it?
Yes, Your Honor. In United States versus Wilson, the Supreme Court explains that the BOP calculates an inmate's term of imprisonment as an administrative matter. And so here, with the First Step Act, the BOP is charged with administering this program and with implementing this ineligibility provision. And in doing so, the BOP must determine whether someone is serving a sentence, and the BOP understands sentence due to the aggregation provision, that 3584, that the sentence is an aggregate sentence.
Does 3584 apply to the Second Chance Act?
So the Second Chance Act is a different type of program, and as I believe you asked.
Everyone likes to say it's a different type of
It is.
program when they don't like
No, Your Honor,
a comparable
and-
statute. So I get it's a different type of program. My question wasn't
Yeah.
whether they're the same. My question was whether 3584 applies to the Second Chance Act.
And I think to kind of further break down your question,
Yeah.
my understanding would be that the 3584 tells us multiple terms of imprisonment, whether ordered to run consecutively or concurrently, must be treated for administrative purposes, right, as a single term. And so I think, to get to your question, really the question is the Second Chance Act, is that an administrative purpose of the BOP? And I think the BOP, I think it would be, that this is a program the BOP is administering, but it's important to remember the difference here between that
I got you,
program and.
and I'll let you talk about the differences.
Yes,
But if the answer is yes, and my instincts would be to agree with you, then it's at least odd that the Second Chance Act went beyond the 3584C, which said aggregated, and had a additional aggregation provision in that statute. And if it already had one in 3584C, why did it need to do another one? And is that not indication, as your colleague would say, that the absence of that one, the absence of that in the First Step Act means you don't aggregate there?
So I think what's important about that, there is a term of imprisonment definition, as Your Honor has pointed out. That is in the Second Chance Act of 2007. So that wasn't in the amendments that the First Step Act did to the Second Chance Act. The First Step Act just added this definition for eligible terminally ill offender. And to make the point I was making about it.
Fair enough, but we presume Congress knows that. I mean, I think it is fair that the additional aggregation section was already in there. But even before that, 3584C was in there before that aggregation provision, the Second Chance Act went into place. So it seems like you either got a superfluous issue with that aggregation language in the Second Chance Act, or you just have a different way of addressing something. I think that Second Chance Act is a problem for you.
I think if there's, to make the point I was trying to make earlier as to the different programs
Yeah.
here, the Second Chance Act is an early release program, and I think we both agree on that. But with the Second Chance Act, there's not a source of additional time credits. So the BOP doesn't have to calculate these time credits as it does with the good time credits, with time served credits, and with the First Step Act time credits. And there's no, looking at the provision, the aggregation provision, there's no language there to suggest that this was limited to one administrative purpose, right? It's in the plural, administrative purposes, and the Supreme Court has told us in United States versus Labonte that at least the good time credits, time served credits, those types of credits fall within this administrative purposes carve-out.
But to tack on, you have to say Congress did know, at least this is some indication when you look at these statutes, Congress did know how to use this language if it wanted to, and it chose not to use it in that particular statute.
Right, and in our brief, we mentioned a district court
I
case
know you
that.
mentioned it, but I mean, how do you get around it?
No,
I mean,
Your Honor,
it's there. I mean, it's right there, and then you go back and it's not.
Right, and in the First Step Act, the silence as to the fact that it doesn't mention aggregation doesn't mean that it doesn't apply. It's a recognition that this First Step Act was enacted in 2018 against the backdrop of an existing statute, the Sentencing Reform Act, that was enacted in 1984, that had the aggregation provision, and that informed and informs the BOP's understanding of what it must do. It is statutorily required to aggregate for administrative purposes.
So I hear you. I mean, on that point, I mean, you know, it may be perverse to me, it may be unusual to me, but, you know, I kind of get when you look at 3584 and 3632, I at least understand your argument. But, yeah, I have trouble with squaring the specific language in the Second Chance Act with your argument. And maybe that's just not enough, that's just a wart in your argument that we have to, you know, no argument's perfect. But I don't, you know, it seems to me just because it's a different program doesn't that doesn't really allow us just to kind of not consider it.
And I understand. I think if there's ambiguity, certainly our position is there isn't ambiguity here in reading the First Step Act in conjunction with the Sentencing Reform Act. But if there is ambiguity, the court can certainly look to legislative history. And there's legislative history that is cited in Mr. Bonney's opening brief and in the amicus brief. That was.
Well, if there's ambiguity, I mean, wouldn't you, what about, I mean, different people have different views of legislative history, let's just say that. And assume some people don't think that's very helpful in discerning intent. If you don't look at legislative history, do you get to the rule of lenity?
No, Your Honor, the rule of lenity does not apply here because Section 3632 in the First Step Act, it's not a criminal statute and it's not the functional equivalent of a criminal statute. So the court wouldn't go to the rule of lenity and also wouldn't get to the rule of lenity because there's no grievous ambiguity or uncertainty here in the statute. But quickly, just as to the legislative history, the amicus brief cites Senator Durbin, and he was one of the co-sponsors of the First Step Act and the Senate bill that became the First Step Act. And the amicus cites Senator Durbin on page 7 of their brief, and there they cite Senator Durbin's remarks about how this was a bipartisan bill. It had support from both sides of the political spectrum, but they don't cite a later portion of a speech on that same day in the congressional record. It's at 7743, the amicus cite 7742 of the record. But at 7743, Senator Durbin said, "Our bill is 60 pages long. More than a third of the bill is filled with a list of over 60 different federal crimes. And we say if you committed this crime, you are not eligible as a federal prisoner for the rehabilitation program in this bill." And Senator Durbin also said, "We want to focus tax dollars on programs that have proven results, and unless they commit one of the crimes that make them ineligible, we offer these to prisoners." So there, even from one of the co-sponsors of the bill, it's clear that if someone is serving a sentence, the BOP is understanding the sentence as it must to be an aggregate sentence, that prisoner is not able to earn these time credits, but they are able to earn, there are other incentives in the First Step Act in Section 3632 that are available to them. There's phone privileges, visitation privileges. There's just not the ability to earn these time credits.
You haven't in qualm with the assertion that the BOP does in fact disaggregate sentences and can parse these sentences for certain purposes?
So this isn't, and I believe my colleague mentioned
That's my question. My question
yes,
is,
Your Honor.
do you agree that the BOP can do that?
Yes, and this isn't a question of whether the BOP can deaggregate, and I believe
And in fact, it does.
there is deaggregation in other contexts, and this isn't a question that, as I said, as to whether this can be done,
And
it's a
you
whether.
have no qualm with saying that one cannot be serving 144 months, a 24 ineligible sentence. In other words, that when you put those together, that he is not serving a sentence for 24 months for the full 144 months. So they could parse them out. That could happen.
So the BOP, this isn't a question of whether this can happen, it's what is Congress required and what is
Understand that.
statutorily
We went there
required.
earlier when we were dealing with the statute, but in terms of, there is an administrative type issue here that you're dealing with. I'm only dealing with what could be done, because if it's administrative, as you indicated, is one thing. I agree, the statute does control here. When you go back into the statute, you're given some legislative history of just Senator Durbin, but there's a whole purpose of this act in terms of to reduce recidivism cannot possibly be fostered if you can negate it with 24 months when it's coupled with a sentence that does qualify for it for 120 months. If we're going to go in terms of what Congress was intending or trying to do outside the statute. But I'm only dealing with just this, what I think your term is an administrative thing of what can be done and the practicality of it. And that is that it can, and in fact, there are sentences that are de-aggregated. And here you got an instance in which you've got this 24-month sentence that is eligible because it's enumerated, 120 that's eligible, 144 months, and then you got that language in the time credit says is serving the sentence. And we all have to agree that one is not serving a 24-month sentence for the entire 144 months. So it seems to me there's a common sense application here that if you can do this, just de-aggregate.
So I would say that it wouldn't be as simple as Your Honor has explained it, in that there isn't any indication in the record for this case or in other cases as to which of these sentences would run first. And it seems that Mr. Bonney's argument would be that he has the ineligible offense, it's 24 months, and that when that's over, then he can earn these
He
credits.
didn't say that. He just says, tell me which one I'm running. I mean, even if it's, I mean, maybe his argument will be one should run before the other one, but even if the longer one runs, at least that gives him, some time to know what he's talking about.
I understand the point, Your Honor. What I was trying to say is that if someone has consecutive sentences,
Yeah.
as we have here, where you have an ineligible offense, an eligible offense, and let's say the ineligible offense.
I don't think, the whole discussion seems to be focusing on an eligible or ineligible sentence, and the statute focuses on the prisoner. The subject of the sentence says a prisoner is ineligible to receive time credits if he is serving a sentence of 924C. So it says the prisoner disqualifies himself because he has been convicted and is serving the sentence under one of the statutes. It doesn't disqualify the sentence, it disqualifies the prisoner from getting credits. And it seems to me that pulls toward anybody who is serving a 924C, regardless what other sentences he has, is disqualified. I mean, if you say a sentence for a 924C violation is ineligible, that would be totally different than saying a prisoner is ineligible. I'm reading from right from the statute itself here, and the subject is the prisoner is disqualified because of particular conduct, because he has a conviction for 924C. And your Durbin language seems to just support that, I'd say.
Yes, Your Honor, and as to the BOP's understanding and what it's statutorily required to do for administrative purposes, that the sentence for the prisoner in BOP's custody is this aggregate term of imprisonment.
But isn't that like taking any one of these words and focusing on it, a prisoner? I mean, who else are we talking about? We're talking about prisoners here. It's the language is serving a sentence. The prisoner is what he's doing. The individual is who he is a prisoner. We know it's a prisoner. He is serving a sentence. And we agree he is not serving this 24 sentence for 144 months. Senator Durbin notwithstanding, it's very clear we don't go around citing statements from senators as legislative history as being anything near authoritative. All kinds of stuff happens on a Senate floor where they're puffing and talking and going on. That means nothing when you come up here. It's nice and it supports your point, and I grant you for saying it. Someone agrees with you, but that's all it means. It's nothing authoritative about it at all. But Judge Niemeyer makes a great and interesting point. If you're going to focus just on the prisoner and the act, yeah, you're going to get there. But this statute is concentrated on is serving a sentence. And what we have here is something that you have admittedly said there are offenses for which, or instances in which the prison has de-aggregated these instances. It can do it here, it can parse it here. So maybe that walks it into a different area, but it gets into this whole question of, if you're gonna say something is administrative, then why are you doing it in this instance and why you're not doing it in that instance? And what is the answer to that? Why is it that some are de-aggregated and some are not?
So the examples that my colleague cites as to the parole commission.
Not your
and
colleague, I
bilateral
want to hear your answer
Yes.
as to why is it that the BOP de-aggregates certain sentences and parse them out and not others?
Yes, Your Honor, and I was just referring to my colleague's examples
No, I
just
want
to
to hear your
answer the
answer.
question.
I understand what your colleague said.
Yes,
I
Your
want to
Honor.
hear your answer.
And my answer is that in those contexts, there's, for example, the treaty. There's a bilateral international treaty, for example, that my colleague has cited, and those are specific types of sentences that are not at issue here, that have specific requirements for the BOP as to the deaggregation. But when the First Step Act was enacted in 2018, it was against the backdrop of this aggregation provision, which is really at the heart of what the BOP does here in terms of administering a sentence.
Is
and
that,
calculating-
just to, I want to make sure you fully answer Judge Wynn, but as part of that, is whatever they did with that treaty administrative? Sounds administrative to me, and yet you're deaggregating.
There are specific requirements within the treaty that requires the BOP to deaggregate, so it's not as if there's kind of a discretionary decision that BOP is making, that it's deciding to do that here. It's
So
this
is your
requirement
position that administrative, I thought you disavowed that maybe you don't. I can't remember what you said about that. Are you now saying that administrative requires discretion?
No, Your Honor. What I'm saying is that administrative refers to, just looking back, which was the Supreme Court told us in United States versus Labonte, what is in this carve-out for administrative purposes? And it is this administration of time credits and sentencing credits, time served, good conduct time, the residential drug abuse program, and the First Step Act's time credits is yet another example that falls into this administrative purposes carve-out. I see my time is almost up, and the final point I would just make for Your Honors is that this issue has been addressed by courts nationwide, and several circuits have concluded that the BOP is properly aggregating these sentences when determining eligibility. And in fact, there's a panel of the Fourth Circuit, I believe Judge Niemeyer, you were on that panel, that upheld the district court's conclusion that there was no error in deciding that someone was ineligible where they had a 924C conviction, the ineligible offense, and then the eligible drug offenses.
Can I, this may take you a little bit over, but no one has argued this, including, Mr. Bonney, but, I wonder if an interpretation, certainly we got to follow the Supreme Court, and if you're right to cite to those cases, so I'm not suggesting we don't, but a way to think about administrative is ministerial. You're just kind of, doing the kind of nuts and bolts type stuff. And that would be as opposed to things that affect substantive rights. I mean, ministerial matters versus substantive rights matters. Is there anything to that, description of what's administrative or not? I mean, that's just me thinking about it, so maybe that's irrelevant. But I wonder if that's not an appropriate way to think about administrative versus non-administrative.
I think it is a fair way to think about this, and if we think about what the BOP is doing here with this ineligibility provision, it has to look at the prisoner and see his aggregate term of imprisonment, and then see if that includes any of these ineligible offenses, and that requires administrative work from the BOP. Just for an example, the 65th offense, so it's not the one we're talking about, 924C, it's another offense relating to trafficking heroin, and it says that this was one of these ineligible offenses if the sentencing court finds that the offender was an organizer, leader, manager, or supervisor of others in the offense. And so there, the BOP has to do some administrative work of looking at the pre-sentence investigation report, the statement of reasons, to see, was this person found by the district court to be a leader or organizer? It's not a decision the BOP can make. It's something it has to do as an administrative matter of looking to the relevant documents to make that decision. So I think that's a fair way to view this.
think your
If there's no
time's up.
questions, I just ask the court to affirm the judgment
Thank
below.
you.
Thank you.
Ms. Richmond?
Thank you. Just briefly, Judge Nguyen, I think that your question about why does BOP aggregate some sentences but not the others gets to the heart of this case, because BOP has conceded today that it deaggregates sentences in other contexts. This aligns with BOP's policies, which, quoting from one about the PLRA and the Sentencing Reform Act, it says BOP doesn't aggregate sentences there because of the statutory differences between the manner in which a PLRA sentence must be treated in relationship to other sentences. And that's Program Statement 5880.28 at page 78K. BOP recognizes that the statute sets the metes and bounds of what it can and cannot do.
So what does that mean? I mean, I think, let's just take that statement or assertion that the BOP deaggregates at times and is not doing it here. I mean, one way, I mean, that might show some arbitrariness that might create an issue in terms of the Administrative Procedures Act. But I'm trying to make sure I understand, if we accept that, does that mean you win? Or does that, because it could still be administrative and they just aren't consistent in it. So I'm trying to figure out, if that's the case, maybe you have some sort of challenge that's a little different, that there is arbitrariness in the application of the act. But if the statute says it's administrative, it's still administrative, and they could do it, but they don't. Does that make any sense?
It does, Your Honor.
Yeah.
I think what it shows is that BOP is following the law when it administers sentences. I think that it disrupts the idea that there's an ironclad background principle that always applies. And I think that in this case, there are pre-First Step Act sentences and there are post-First Step Act sentences. Congress said people couldn't earn credits for programming they participated in prior to December 21st, 2018, when the First Step Act was enacted. So there's a post-FSA regime. And I think, as it has with other conflicting sentencing regimes, BOP has the ability to administer those differences.
But it seems to me you got to grapple with 3584, and you got to say, look, we don't even look at that, because, when we're looking at 3632. Or just as a general proposition, or you guys say we don't look at it because of it's not administrative. And I hear your brief goes the latter way, I think. And that's why I asked the question, because if it's administrative, whether or not if they selectively do it, that may be bad, and that may subject them to some issues. But I'm not sure from a statutory interpretation context it makes as much of a difference.
Why don't you answer that question? We don't have a light for some reason, but
That's bad for me.
no, I don't know what happened. I don't think we reset the light here, but why don't you go ahead and answer his question, and we'll call it a day.
All right, thank you, Your Honor. I think that there are aspects of the First Step Act credit program writ large that are administered by Bureau of Prisons. I don't think eligibility determinations are one. I don't think assigning a particular sentence to a particular term is one. I think that's done by the court. The last thing that I wanted to do was to give you the citation. I mentioned JA 94 is where it shows the computation of the elderly offender credit, and then just to thank the court and ask you to please reverse the district court with a direction to deem Mr. Bonney eligible to earn credits. Thank you.
Thank you. Ms. Richmond, you have this status. You were appointed by the court, right? But you're a
Yes,
public
Your Honor.
defender.
Yes, Your
But
Honor.
we still want to recognize your service. You helped Mr. Bonney out and we have a very interesting issue we've presented, and you've done a nice job. And thank you.
Well, thank you, Your Honor. Thank you for appointing us to represent
All
you.
right. We'll come down and agree counsel and adjourn for the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.